I'm Kathryn Hoffman. I'm the CEO of MCEA, and with me here is Kevin Reuther, our Chief Legal Officer. All right, so we did one of these webinars last week, and we spent a little time introducing the PolyMet issue more broadly, what's happened in the project proposal, all of the permits, all of the legal challenges. So we're not going to do that today. If you are interested in that background, then you should check out the other webinar that we did. It's at our People versus PolyMet website. That's peoplevspolymet.org. It's right, yes, thank you. And it's right on the front page of that website. So you should watch that if you haven't. Today we're going to focus a little bit more on what happened in these hearings that just wrapped up yesterday and that Kevin has been very patiently sitting through.
Yes, 2 weeks of trial.
Yes. So let's go drill down into this permit in particular. What permit is at issue here for PolyMet?
Okay, so PolyMet has to get a number of different permits. And the permit that this case involves is the Clean Water Act permit. The Clean Water Act prohibits the discharge of any pollutants into waters of the United States without a permit. And so PolyMet obviously is going to be discharging pollutants. They need to receive a permit from the state in order to do their project. These permits are issued sort of in a collaboration between the federal government and the state government. The permitting authority is the Minnesota Pollution Control Agency, but the federal EPA also plays a pretty big role in these Clean Water Act permits because the Clean Water Act is a federal law. So that's the permit that this case is about.
All right, so what did PCA allegedly do that dropped us into these hearings? What's the problem here?
Well, the problem is that MPCA sought to exclude EPA's comments about this permit from the public record. I think, as you know, Kathryn, EPA has been super interested in this project for a long time. Maybe you should talk about when you were working on the project years ago.
Yeah, so this was my case starting in 2010 before I stepped into the CEO role. And at the time, I mean, for the entire time I was working on the case until 2016, EPA was really active. So they would have regular calls with PCA that we would hear about. They would comment at every opportunity, notably on the environmental impact statements and the drafts. They actually were a big part of the reason that an early draft of the environmental impact statement had to go back. They had kind of had to start over, is because EPA gave it a failing grade. They said this isn't very good. Under the standards of the environmental review law. And so PCA staff, or excuse me, EPA staff have really cared about this project every step of the way. And I've actually been very impressed at their dedication.
Yeah, and so with this water permit, the application came into the state from the company in, I think it was July of 2016. And from like, I don't know, end of 2016 through 2017 into 2018, EPA was meeting with the PCA staff about this specific permit almost every other week. And so they made their intent to, comment about the permit very clear to the PCA staff.
Yeah, so why didn't they?
Well, what happens in these cases, and maybe I'll just explain this really quickly, is there has to be a public comment period where the public can comment, organizations like us can comment, and typically also EPA would comment. And by comment, I mean write a comment letter. You comment, typically in writing.
Right, and they would say, here's the parts of the permit that we think are effective, and here's some parts we might have concerns about or would like to see strengthened.
And EPA participates in that comment period. I mean, so other mining permits that you've looked at, they've commented during the public comment period, I'm guessing.
Yeah, that's right.
Yeah, it's pretty typical. Now, there are plenty of permits that they're not concerned about, but something big like this where they've been involved, they're going to comment during the public comment period. Here we are, MCA, working on our comments. We're assuming that EPA would be commenting. We get to the end of the public comment period, and there's no comment from EPA. So that's really strange.
Yeah.
And as it turns out, what we've now discovered is that the PCA was working behind the scenes to get EPA not to submit that written comment during the public comment period. As a result of them not submitting something in writing, the PCA had no record. Like, we didn't get to see whether EPA, what they thought about the permit. PCA also didn't need to respond to the critical comments that EPA wanted to put in. What we know now is that EPA, in fact, did want to comment, and they actually had drafted a very detailed comment letter. This is an 8-page letter, has about 30 different specific points that EPA wanted to make about this permit. And in fact, some of these points the EPA refers to as objection points, meaning that if they didn't get resolved, EPA could reject the permit and it would have to go back to square one and be redone. So the only reason we know about that letter is because it was leaked from EPA in Chicago.
And so this letter has this is the version that was leaked, and it has a note on the top. It says, the information underlined in the attachment to this letter was conveyed verbally to MPCA on April 5th, 2018. This was read word for word to PCA participants, and then there's a series of names of PCA staff and which EPA staff. And it's signed by Kevin Perard, who is an EPA employee, and dated April 5th, 2018.
Yeah.
And so they had this comment period all ready to go, and for some reason they read it over the phone.
Right. Highly unusual, by the way. I want to just read to you one piece of testimony that came out in the trial. This was from the supervisor of the permit writer at the Minnesota Pollution Control Agency. He's worked for the agency for 30 years. And he was asked, and he stated in the 30 years that he's worked there, only once has EPA ever commented by reading their comment over the phone.
Just once.
Just once.
And that was Molly.
And there you have it. So fairly unusual. So how did we get here? Well, what kind of came out in the trial is that I think it was the line staff, or at least the manager of the mining division, that first floated the idea to EPA that PCA did not want to receive their comment in writing. There was a conversation between that mining manager for the state and Kevin Perard, the guy who you were referencing there. And Kevin Perard pushed back and said to the mining manager, no, we're planning on commenting. That would be really odd, and it would also be a problem for transparency. So then it appears that the mining manager took this up the chain, and he went to the assistant commissioner for water at the time for the PCA was Shannon Lotthammer. There's evidence in the record that Shannon Lotthammer then was contacting her equivalent, so Kevin Perard's boss, in Chicago and making the same request. And I think that she got a little bit pushed back too, initially. And so she then went further up the chain to the commissioner of the Pollution Control Agency, who at the time was John Link Stein. And there's evidence and testimony from the hearing that Commissioner Stein then called the regional administrator, the top gun in Chicago at EPA, who at that point was Kathy Stepp. She had just been appointed by President Trump, she's pretty new, had been there a month or two. And it was those two who I think made the agreement that EPA would agree to not put their comment into the public record. And so there's a series of emails kind of back and forth between her deputy and Shannon Lotthammer that hammer out this agreement. In exchange for not commenting during the public comment period, the PCA says that they will give EPA an additional 30 days to comment later if they want it. So the evidence is pretty clear that this request came from the MPCA. In fact, we have an email from Shannon Lotthammer. If you can bring that up, we'll show it to you.
60.
Yeah, it's Exhibit 60. And you scroll down there. So the highlighted sentence, you can see this is a email from Shannon Lothammer on March 13th. That's Tuesday. The comment period ended that Friday. And she's saying, we have asked that EPA Region 5 not send a written comment letter during the public comment period. Again, we only have this email because it was leaked from EPA. Shannon Lothammer deleted this email from her computer, and it was never provided to us from the PCA, and is not available in the PCA's documents, and obviously was not part of the public record that went to the Court of Appeals when we appealed this permit.
In general, it seems like PCA didn't keep a lot of documents around this time period or from these meetings.
Right, that's one of the big problems that we've discovered here is, well, so for example, we should talk about the meeting that PCA had with EPA where this comment was actually read over the phone.
Right, so Perard is super clear. I read all of the underlined parts over the phone to these PCA staffers.
Yeah, so they had been having these bi-weekly meetings. The permit writer had been keeping detailed notes of all of these meetings all along. They are in the record. We've received them through the Data Practices Act, and they were available at the trial. Surprisingly, there were 0 notes taken at the meeting where EPA read its comment letter over the phone. And it wasn't actually until the first day of the trial that we found out that there were, in fact, notes. What they did was they had an attorney as part of one of the people from the general counsel's office attended these meetings. And the attorney was the person who took the notes on the day that EPA read its comment letters. And the attorney went back to his office, typed those notes into his computer, and threw away the handwritten notes. And then PCA apparently believed that because the attorney had written the notes, they didn't need to produce them in response to any of our data requests or any of the discovery during the hearing. Well, we challenged that, and the judge reviewed the notes and determined that actually they were primarily just, he was functioning as a scrivener, not as an attorney in these meetings, and that his notes were, in fact, they should have been provided to us. And so we did get a copy of them in the end.
Right, because if he's giving legal advice or if it's his thought process, that's privileged. But if he's literally just taking notes, that's not privileged.
Right. And so those are some notes that do exist. But throughout this process, PCA has, they've really worked to scrub their computers, delete emails, and keep things from the public in ways that are pretty concerning. We discovered, for example, that they scrubbed the computers of former employees 30 days after the employee has left. So we were seeking documents from the commissioner about this exchange that he'd been having with Shannon Lothammer and EPA. 30 days after he left, they destroyed his computer. There's no documents available. Same thing with the former mining director. So it was at the end of 2018, is that when Ann Voss retired?
I think so, yeah.
Yeah, basically the permit got issued and then the mining director retired, and 30 days later they scrubbed her computer. We don't have any of her documents from this entire period where they were developing the permit. So that's problematic.
Yeah. Well, and then later on, once this information started to come out, how did PCA respond to that?
I guess I'm not here to call anybody a liar, but
right.
It seems like there are some gaps in the truth. I brought one other exhibit that I thought we could show folks. This is, yes, that is the exhibit. This is a email that came originally from a Star Tribune reporter, Jennifer Burris, and I think we have what she was requesting highlighted there, yeah. So this is after some of these things have started to leak, and we don't yet have this letter But we know that something fishy's been going on, and so Jennifer writes this email to the agency wanting to confirm that EPA did not give the MPCA its final comments on that permit in some other format. Say, for example, via telephone with no notes taken or something like that. This request gets sent up the chain. It goes to the mining manager. It goes to the permit writers, her supervisor. It goes to Shannon Lott-Hannemer, the assistant commissioner. And their response is to say no, that they have nothing, that there were no comments from EPA.
Yeah, okay, well, that's concerning.
Yeah.
So we do want to take some time for people's questions. So let's just go briefly over what happens next.
Okay.
The hearing wrapped up yesterday.
It wrapped up yesterday. The judge said that we have 30 days after the transcript is available to put in our final arguments. So we'll do a final written brief and some proposed findings. So that'll happen probably within the next 60 days or so. Mm-hmm. And then the judge will take some time to issue his ruling. I think that initially the judge was very concerned to wrap this up quickly. It feels like now he's taking a little bit more time, and I'm assuming that that has to do with the fact that the permits have been reversed by the Court of Appeals. And so I think that there's a little bit less urgency to get this wrapped up.
The DNR permits.
Right.
Right. So even if this permit was issued to PolyMet and they could go forward on the Clean Water Act permit, they still couldn't go forward because they've lost the other permits.
Correct.
Right.
Yeah.
They have multiple problems.
Yeah.
Okay. All right. Well, that's helpful. Let's see what kind of questions we have. Can you bring those up? So the questions would go into the Q&A box. So one question is, what are the EPA concerns that PCA was trying so hard to keep out of the record?
Oh my gosh, there are a number of them. They get a little bit technical.
Yeah.
But they have to do with, at the base, really, it's about whether the controls that are going to be required of PolyMet are enforceable. I don't know how deeply we want to go into that, but
well,
kind of at a high level, yeah. What the agency did here was to require controls on the front end rather than at the discharge point. And it's not really clear that those kinds of controls are enforceable under the Clean Water Act through the citizen suit provision.
Right. Right. So the question is, if there was a violation of PolyMet's permit, can anyone do anything about that?
Yeah.
Is the question that EPA raised.
Yeah, exactly.
Yeah. They also raised questions about mercury.
Yes.
Discharged from a particular waste pile that wasn't regulated, right?
Yeah.
Yeah. So these are not, technical minor issues. These are really important fundamental questions that go to the effectiveness of the permit, right?
Right. Yeah. They are.
Yeah. All right, let's see. Another question is, what is the percentage of public comments for or against copper nickel mining, and how much weight do public comments have in the court? So this first one I can weigh in on.
Yeah.
So people will probably remember that there was a comment period on the draft, the supplemental draft EIS in 2015, I think, and that it was the largest volume of comments that any state agency in Minnesota had received on any issue, and that was 58,000 comments. And we were at the time part of the Mining Truth campaign, and we had some interns go through, and this is an exciting summer for college students, I'm sure, read all of the comments, and they classified them. This comment is, in favor of the project, it's opposed to the project, or it's neutral. And what we found was that over 98% of the comments were opposed to the PolyMet project in that 58 of those 58,000 comments. So it's pretty clear that there's a motivated public that has a ton of concern. The second piece, how much weight do they have, is a challenge. I mean, I don't think they have any weight at all with the court. And I would say, in fairness, as a lawyer, nor should they. right? That's not what the court decides on.
Mhm.
They should have some weight with the agency and the governor's office. And I think it does lead you to, I think the next logical question would be, you know, if we have comments now, who do we contact? And I do think there's value at this point in time in calling the governor's office and calling your legislator and letting them know that you have concerns about this project, because that's still, you know, whatever happens with this and the other permits going forward, there's still going to be opportunities for the governor to weigh in, and for the people who work for him, the PCA and DNR commissioners, to weigh in.
Yeah, I agree with all that. Should we take this next one? Is there any evidence that the governor or legislative leaders were aware of the MPCA dealings with EPA at the time they occurred? If so, what were their opinions? And the answer to that is no. We didn't find any evidence that at the time this was occurring, so during the public comment period, that the governor's staff or legislators were made aware of it.
Yeah.
Has PCA provided any new explanation for their actions? So, I mean, PCA's story has had to sort of morph as more and more information has come out. And, you know, the reason that they gave, most of their witnesses provided the reason of efficiency and staff workload as the reason that they didn't want to have the public comments come in from EPA. So one of the things that people have to understand is that all of the comments that are received during the public notice period have to be responded to in writing. And so I guess there, you know, it might have been a legitimate concern. Now, we don't want to have to respond to EPA's comments in writing, but I don't know. I mean,
but they did every other time.
They did every other time.
Sort of, that's just part of the job if you issue a permit.
It's also just a really important way of informing the public of who's concerned about what issues. And, you know, EPA, they're the experts. Their concerns are the most important of all of ours. So
right, and there was some conflicting testimony on this, right? Didn't the EPA, Kevin Perard, who wrote this letter, didn't he say that PCA had suggested there might be some other reasons at the time, like public confusion?
Yes, exactly. Public confusion and also media attention.
Right.
They were concerned that, you know, there would be a lot of publicity and media attention if they got a critical letter from EPA, which this is quite critical.
Right. The public might get confused if there's problems with this project.
Now, the PCA witnesses didn't testify to that. But.
Right. Yeah. So there's a question about, is this likely to cause a project to shift towards dry storage, which is kind of interesting. So one of the issues in that we as an organization and others as well have raised about PolyMet is that they're storing a lot of their mine waste in a wet storage facility with a tailings dam. And tailings dams, similar to the one that that PolyMet wants to build, have collapsed in other locations and caused ecological destruction and actually killed a lot of people at one that happened recently in Brazil. And so we have real concerns about PolyMet pursuing this strategy. And there is another way to do it, which is to dry the waste out instead of storing it all with the wet stuff. Now, that particular question is not really at issue with this permit, right? So that question has been raised in the DNR permit to mine. But the court did weigh in on that a little bit, right, at their permit to mine decision?
Yeah, the Court of Appeals.
The Court of Appeals, yes. Mm-hmm. In the earlier proceeding, they concluded that
we're going to get a contested case on that issue.
Exactly. Mm-hmm. So I don't know what the outcome would be, but at least we know now that assuming that decision stands, and we don't know what will happen with the Supreme Court and whatnot, but that eventually we will get a hearing in front of an independent judge on this question of whether PolyMet's wet storage strategy meets environmental standards in Minnesota.
And is safe.
Yeah.
Mm-hmm.
Yeah.
There's a question here. State agencies don't operate in a vacuum. That's very true. Do you think PCA and DNR received or are receiving pressure from Minnesota legislators or the governor to approve PolyMet's permits does that mean our comments to them need to be more forceful? You're very right that this is a political decision in a lot of ways. I will say that the Commissioner, Stein, under oath testified that he did not receive pressure from Governor Dayton to approve this permit. You can look at the timing of when the permit was issued and, you know, conclude some things. I think it was issued in late December of 2018. And so I think that, you know, Governor Dayton's agencies really wanted to get this out the door before the new administration came in.
Yeah, and we don't know specifically who that came from, but evidence certainly suggests that.
Yeah.
Yeah. You know, the other piece of that I think is worth noting is that DNR as an agency has two, you know, primary roles around mining. One is to regulate mining as an industry, but the other one is to promote mining and mineral extraction from an economic development standpoint.
Mm-hmm.
So if you look at their findings for the permit to mine, the very first finding is, you know, we have an obligation to promote mineral extraction and mining, and therefore we're going to issue this permit. So, you know, even independent from political pressure, DNR itself has a statutory duty to move towards more mining.
Yeah, I mean, it's sort of a built-in conflict of interest in the statute.
Yeah, yeah.
Any chance that the EPA comments would increase the financial assurance required of the project developer? That's an interesting question. Again, this kind of is related more to the DNR case, because the financial assurance package is part of the DNR permits. And that will also, if we do get this contested case hearing in the end, it'll be one of the topics that gets discussed for or at the contested case. What kind of financial assurance should be required? And I could, you know, who knows what's going to happen in a contested case? In theory, EPA could weigh in officially. Obviously, it'll depend on many factors, what's happening at EPA when we're in the midst of a contested case, but yeah.
Yeah. So our last question, and then we'll wrap it up here, is the EPA's purview over this project limited to the Clean Water Act?
Nope.
No. Maybe we should say more.
There's also, well, you already mentioned the environmental review.
Right.
So they were very active in the environmental review in the EIS. There's also a Clean Air Act permit, and EPA has a role and can comment on permits under the Clean Air Act as well.
Mm-hmm.
But I would say that their main concern here was with the water permit.
Yeah.
Yeah.
I think that's right. All right. Well, thank you all so much for joining us. You should definitely check out our website, peopleversuspolymet.org. It has a lot of great resources. Many of the papers, pleadings that were filed are there as well. And thanks so much for following us tonight. Have a good one.
Good night.